Good evening, everyone. I am super excited. This is our last Black History special live stream with attorney Barlay, and it's actually our third live stream. So we've been doing this for now 3 years, or going on about 3 years that we've been doing these live streams. So in the description of this video, I'm going to post all the live streams from year one, year two, because he's been with me all of these years. And I think, attorney, you've helped some people get their trust or their wills together over these 2 years.
Absolutely have, yes, and they always remind me of where they heard my name, and from it was from probably the original live that we did. So
Okay.
definitely a good thing to be able to help people.
All right. Awesome. So, for those of you for people that don't know you, please explain who you are.
Well, my name is, and thank you again, Shahida, for allowing me to come on this live stream with you. My name is Thua Barlay. I'm an estate planning attorney with Lueder, Larkin, and Hunter. My main office is in Conyers, Georgia, but we service the entire metro area. We have about 29 offices in the metro area, and I lead the estate planning practice for the firm. I've been doing estate planning now for about 15 years. So still not an expert, but I'm getting there and
Gotcha.
working on it. But it's a good part of my practice.
Good.
So
And you
glad
do
to be here.
closings as well, correct?
I'm sorry.
You do closings as well?
That's right. I do two things and two things only. I do real estate closings and I do estate planning. The real estate closings, I've been doing it for about 20 years. Estate planning for 15 years. So as my running joke, I try not to practice what I call rent law. Whatever pays the rent, I try not to do that. I focus on those two areas, and that's all I do.
Okay, very good. All right, so we're going to get started. The title of this video, I titled this live stream, Black Wealth Lost in Probate Court.
Yep.
Like, because for Black History Month, I'm really focusing a lot on wealth and, building wealth. And I know as our loved ones, our parents, our grandparents, aunts, uncles pass away, and they're passing away without wills, without trust, we're losing some of that money, be it for not paying taxes,
Right.
for not having a will, and having to go to probate court. So can you talk about the importance of a will or and a trust, and then explain the difference?
Correct. Well, they're absolutely important. So those are what I call vehicles. They're vehicles for allowing you to pass or transfer wealth upon your death. It allows you to maintain a certain level of control because you get to dictate how that gets transferred. So I tell folks all the time, just because you have 3 or 4 children doesn't necessarily mean that they all need to get equally. Some may have done exactly what you wanted to throughout your lifetime. So this is your opportunity to be as subjective as you would like. And so you get to dictate how they get it, when they get it, or even if they get it. And so that's the importance of getting a will or a trust. Now, the primary difference between the two, and as I mentioned, I like looking at these as sort of vehicles. In fact, when I explain the difference between the two, I talk about them as a car. So it's the same make and model car, whatever is your favorite car, it's that same make and model. The difference primarily is that with the wheel-based car, when you die, that car has to go into the shop to get tires rotated, oil changes, etc., before it's ready to go on that journey. So in my analogy, that shop is the probate court where you have to petition the will. So and that's a clarification that most people don't understand. Just because you create a will is not the end all of that process. Once you die, whoever has the will has to take it to the probate court or petition the probate court for the executor under that will to be given the authority to act on behalf of the estate. So that's really part of the probate process. Petition the court, get the authority to act on behalf of the estate as the executor, and then you'll be able to do everything necessary for the estate. And we can talk about that process in more detail later. Now, in the trust-based car, when you pass away, because you've been doing tire rotations and oil changes throughout the life of the vehicle, and all the baggages or the baggage is already in the vehicle, it's automatically ready to go on the journey. The only thing that happens is that the chauffeur or the driver replaces you from the driver's seat. They get in and they're able to drive that vehicle. So for the most part, it's the avoidance of probate that makes it the difference between a will and a trust.
Okay, so start putting your questions in the chat. You're getting free attorney advice. So, and that's, usually attorneys try to bill you by the hour, right? So get your family questions, title, closings, estates, all of that stuff. Start putting that in the chat so he can answer it. Angela Jones said, Let me
And
pull that up.
before she answers, because that's a great segue in a sense, because I forgot to give my disclaimer.
Oh,
This is
disclaimer. Go
purely
ahead.
educational for educated purposes only. Do not hold me to any legal advice provided here. I'll try not to speak to specific instances. We're talking generalities in this particular discussion, because my main point here is to educate you, because the better you know, the better you're able to handle things on your behalf or on your loved one's behalf.
Okay. And Angela Jones said, great analogy. She liked the analogy of both cars. Okay. So that's awesome. I'm
Thank
trying
you,
to
Angela.
think what else. Let's talk about this while we're waiting on questions. Go ahead and get these questions in. Okay, so a lot of people in the Black community are dying without wills or trusts, nothing. And the children know that they don't have a will or trust. So, what typically happens if a parent dies, they own a house,
Okay.
and they have, say, 3 children?
Mhm.
What's going to happen? I know we have to go to probate court
Correct.
to make that happen. But is the house going to be sold? Will they give it to the child that's the best child? Like, what does a judge typically do?
Well, that's a great question. So in Georgia, Georgia has what's called a law of descents. And basically in the statute, in the law, it tells you exactly how things are to happen in terms of the distribution. Now, it won't speak directly to what happens to the house, but more or less it tells you, well, how is it separated? So if somebody dies with a spouse and children, let's start simple. So if somebody dies and only has a spouse, then Georgia law says that that spouse will inherit all of the estate, including any primary residence or house that you may have. Now, if the person dies with a spouse and children, then what happens is that the spouse and the children share equally. But Georgia law specifically says not less than 1/3, meaning the spouse cannot get less than 1/3. So if the person that passed away has, let's say, 3 children, then the spouse would get 1/3, and then the 3 children will share the 2/3 there. So
And then,
that's how it's dictated. Now, we can get more complicated because there's a thing in Georgia called year support that only Georgia has, where the spouse can ask for X amount of the estate and receive X amount of the estate, typically all the estate, even though Georgia law says or the distribution says otherwise. So sometimes you help family members, especially spouses, by applying for what's called year support. But in general, it splits everything out equally amongst children, regardless of relationship and regardless, again, of how they're related to the surviving spouse or anybody else. These are children of the person who passed, biological children of the person who passed away,
okay.
regardless of whether you're estranged, whether you haven't spoken to this person in 20,
Whether
30
they don't
years.
like you.
You are an heir now. Absolutely.
Right.
Yes.
Okay. And that we talked about Georgia. Is that like that in every state? Every state kind of has, this is what happens if somebody dies in Florida, in
Correct.
California,
So
in Texas
every
without
state
a will.
tries to predict and dictate exactly how it's supposed to work. So for the most part, every state has these laws telling you exactly how. So spouse, if no spouse, then children, if no children, then parents, if no parents, then brother, siblings, if no siblings, then aunts, uncle, nieces, nephews, second cousin, first cousin. It just keeps going down till they
Right.
find somebody
So they
to
find
inherit
somebody.
from you.
All right. So we got some questions. Let's talk about it. Angela's first. Are trusts more expensive to acquire than wills?
And the answer, yes, they are. So the way I look at trust, obviously, is the avoidance of probate. That's the most important part. But one of the reasons why trusts avoid probate is that you do what's called funding of the trust, meaning the reason they avoid probate is that when you die, none of the assets are you in your individual name. They're all in your name as trustee of the trust, which basically means they're all in the trust's name, and that's why you tend to avoid probate. So part of the expense is not only the drafting of the document, but it's the process as well in making sure that each asset that you own is transferred to the trust. So your primary residence goes from your name individually to you as trustee of your trust. The same thing with bank accounts and insurance policies, 401ks, any other retirement accounts. We transfer that process. So the way I like to look at it is sort of like heavy lifting. With wills, the heavy lifting is done after you die, because then it's your executor's responsibility to transfer assets to the estate and distribute those assets. Whereas with trust, the heavy lifting is done upon signing or creating the trust, because that's when you're doing it. And so when you ask me who's in the better position to do the heavy lifting, I would say always the person who owns those assets, because you know where they are, you know the policy information, you know the contact information to get those things in. Imagine trying to do that as an executor. Unless the person was well organized, you now have to figure out, well, what accounts, policy numbers, where the accounts are, who to contact. So there's a lot of work done in that. But I
In the
know
front, the trust
in
is done.
short,
And from my experience, in the car analogy, we don't want to be walking. We want a car. We want some kind of car. But in
absolutely.
the car example, a will is like a Kia and a trust is like a Mercedes.
Yes,
like
yes.
that.
Well, but you see, and well, I hesitate because remember I said it's the same make and model, same car.
Same make and model. Okay.
So the reason why the question's a little misleading in a sense is because trusts are expensive upon inception. When you create the trust, they're more expensive.
Right.
Wills tend to be more expensive on the back end because either you have to do probate fees, or in some cases you have to hire a lawyer to be able to petition the court to do that. So I tell clients all the time, they almost even out in terms of cost. The question is cost up front versus cost on the back end.
Because basically you're dead and your estate is paying, you're paying
Correct.
for it.
It's paying for it. Now with
your
the
estate
trust,
is still going to pay for it after you die.
Correct. Now with most trusts, you don't have to have probate. You don't have to have an attorney's need, especially the trusts that I try to create. They're very straightforward. We try to stay away from legalese. We try to use language that even the somebody who does not have a law degree will be able to follow. Even at the back of most of my trusts are a glossary of terms. So if I use something like per stirpes or some fancy terms, it's explained in the back there as well.
Okay. So Anna Marie has a question. Do you still need an executor for a trust?
So love these questions. So the general answer is no. You do not need an executor for a trust because that person is called a trustee. Now, where I tell clients all the time, you still have a will when you do a trust. That will is called a pour-over will. It is simply a catch-all. It's simply in the case that not everybody redirects something into their trust or they acquire it after the fact. So if you die and there's something not in a trust, you need a will that's a pour-over will. It's skeletal. It's there to be able to have your executor go to court, take that asset that wasn't in the trust and pour it over or add it into the trust. So in general, no, you don't need an executor for the trust itself, but you do need one for a pour-over will to be able to add anything that was not added to the trust initially.
But you need a trustee. Like you need somebody that's going to handle your business. Even with
Correct.
a trust, you need somebody that's going to handle the business. Like mine is, I have a trust. Now, I didn't get it from attorney Barlay because I didn't know him back then, but I paid $1,500 for my trust. And it was on sale. Like seriously,
I was going to say that's sale. Absolutely.
The attorney had a sale. I don't know if it was 50% off or something, but she sent an email out and I jumped on it. So I don't know what the regular price is. I know it's in like the lower thousands to get a trust. And I think it depends on how many people and that sort of thing as well. So it was me and my husband. I have 2 children.
Correct.
At the time, it was probably like 5 years ago or so. I paid $1,500. So y'all can get an idea. But, you know, I was going to say this. And my cousin, I picked the person that's the most frugal person in my family. I made her the trustee of our trust. If we both die, if I die, my husband's a trustee. If we both die like together, then she takes over, and she has a flash drive of my trust, so she knows what to do in the.
And that's actually a good point on both cases. The first point that I'd like to point out, I have in my office what I call the rule of 3. I want my clients to identify 3 people. So if the first person's not available or has passed away, then you have a backup, and then you have a backup. So that so that you don't always have to amend trust just because somebody decides, hey, I don't want to do it, or they've passed away. And so you have those people in place to be able to act as backup. And as to Shahida's point, pick somebody. And I always ask clients, and sometimes clients, I ask these what I call innocuous, these simple questions about what the person does and how do they manage, how's your relationship with them, how do they manage money, because it's important. This is the person that's going to be responsible for your assets, so you want to make sure that it's not just anybody simply because of the relationship. I tell people all the time with your children, well, what do they do, how close are they are to you? Those are the important things there. If
Okay.
I had it my way, hey, what's their credit score? Because the higher the credit score, the more likely they're going
You're
to
gonna have
make
to
sure.
interview these trustees.
Absolutely.
Right. All
Do
right.
some interviewing.
D. Inman has a question. What does a quit claim deed do? Someone said it's like a will or a trust. You got some bad advice already, but I'm gonna clear it
Correct.
up.
Yeah. So a quick claim deed is so there are various types of deeds. Let's talk about deeds in general. Deeds are documents that we use to convey or transfer real property from one person to the other. The general type of deed is called a general warranty deed. That's basically saying, hey, I'm giving, so A transfers to B general warranty of the property. A is telling B, I'm going to guarantee you from not only when I own this property, but from everybody before I owned it onward. So if there's any issue or problem, I'm going to sort of protect you or guarantee this that I'm transferring it to you. The next layer of deed, what we call a limited to warranty deed, that's where A is saying, hey, I'm only going to guarantee you when I purchase the property on forward. So everything behind me, I really can't guarantee or promise you that it was good, but I can promise you from when I did it on down. A quick claim deed is basically saying, hey, I'm just giving you this property. You're going to take whatever you can. I'm not guaranteeing you anything, including when I own the property. So that's what a quick claim deed is. So I would be careful with trying to compare a quick claim deed to a will. Again, it's simply a conveyance. It's simply a transfer of title on to the real property. Now, can you use deeds in relation in relation or in the same sort of plan with wills and trusts? Absolutely. So in if you can't, let's say you have a spouse, and two of you own property, you want to own it as what's called joint tenants with right of survivorship, meaning that if you bought this property and gave in the deed, hopefully not a quick claim deed, but you purchased it with either a limited warranty deed or a general warranty deed with two people, you want to own it as joint tenants with right of survivorship. What that means is if one spouse passes away, the other spouse automatically owns the property. So there does not need to be a probate or anything that occurs. It by Georgia law, the person automatically owns the property. So that is in essence almost like planning. So you don't necessarily have to plan in terms of a will or trust for that particular property, because then your spouse would own it. But be very careful. Again, what I said was joint tenants with right of survivorship. So that means the language has to be behind both your names. So those who own property with a spouse, go back and look at the deed. Hopefully not a quick claim deed again, the limited warranty deed that you purchased ownership from it. And after both your names, if joint tenants of right of survivorship is not on there, then Georgia defaults to what's called tenants in common. That means if one person passes away, their half of the estate goes to their half of the property goes to their estate and not to the other person. So that's a situation where if you don't have a will or a trust, you could now have to create a probate just to simply get that half of the property from the spouse to the other spouse. So it's a great question, but
Okay. And
again,
I think what people try to do is, so if you have a parent and they don't have a will or a trust while they're still alive, they're like, well, I'll just quit claim deed this house to you, and then we'll avoid the whole thing because all I have is my house.
And there's several, and when we get those questions and requests all the time, and there's a lot of things, and if you talk with your accountant about that, there's things called step up in basis, and that's outside of this discussion. But there are tax implications that may occur with doing that kind of a transfer.
Because
So
you're
you really
gifting
want to
that
talk
house to the
correct when you're adding it
relative.
or when you're transferring it to a child. So I wouldn't transfer it entirely to the child. I'd probably add the child as joint tenants with right of survivorship after again consulting with whoever does our taxes to make sure that doesn't create any tax impact on the child when they turn around after the parent passed away and tries to sell the property. So definitely again ask questions before Googling or trying to figure those things out on your own.
Gotcha. Okay, Attorney Barlay. We kind of talked about the cost. I talked about what I paid. Can you give a range or so of what
Oh,
people are going to pay for a will and a range of what people are going to pay for a trust?
absolutely. And I'll speak to my firm directly because I can't with other attorneys. So For us, as you mentioned briefly, Shahida, there are, depending on whether it's an individual trust or joint trust. So our individual trusts begin at $3,500 and our joint trusts begin at $4,500. And I always say begin or start because it's important. We customize the document to the particular client. And so, yes, if you're on the simpler side of things, then it's closer to the cost that we mentioned. If it's more complex, then it's that. And it's not necessarily in terms of the number of assets that you have or the amount of money that you have. It's really about how complicated the estate is. And I always use the example of, I have two potential clients. They both are, let's say they both own 500,000 or let's say a million. Sounds great to be a millionaire. So they both have $1 million, except the first person has $1 million, but they have 5 children, 2 of which are minor, one's in jail, and the other 2 are great. In fact, they're lawyers or doctors, so it's great. The other person is a millionaire with 5 children, but they're all adults. They all have great jobs and no issues, right? So you can see where with the person with the minor children, incarcerated or some other issue or problem, we have to solve more issues. We have to keep things perhaps in trust away from either them or their creditors. And so that plan would tend to be more expensive than the plan of the other individual. So that's really what it is. It's about trying to resolve issues. Now, I saw the last part of his question, how many things can you put into the trust? There's no set number of things. You put all your assets in the trust because, again, you're trying to avoid probate. So you put all things into the trust. I don't know if we'll get more complicated in terms of the structure, but let me talk briefly about how some of that is accomplished. So as I mentioned, every asset goes into your trust. So if you own a company, the company goes into the trust. If you bank accounts, life insurance, real property, anything that you own goes into the trust. The way that I want my clients and public in general to think about trust is like a holding company. The trust is your holding company, and underneath the trust is everything that you own. So if you own a company that has investments properties, so the investment properties are in that company, and that company gets put into the trust. So indirectly, your investment properties, the properties themselves will go into the trust based on that sort of direction. So to answer your question, everything should be in the trust.
All right, good question. All right, lovely Lisa. My mom passed away more than 14 years ago. Sorry to hear that. Without a will. Her home was left to me and 4 siblings. We did go to probate. One sibling has lived in the home and refuses to leave the home. And these are the kind of dramas that your parents leave you behind with, right?
Correct.
What now? What should they do?
Yeah, and lovely, or Lisa, I'm sorry to hear about your mom passing away. And I tell clients all the time. So it's funny because I have these conversations with clients, and they always say this one thing: "Oh, my children get along so well. They love each other. They're great." And I always say, yeah, "Wonderful, that kumbaya world, the utopia, wonderful."
Right.
But let's say real world. If they don't, what would you like to have happen? So in this situation, again, I try not to lean towards legal advice. What would end up having to happen in this case is whoever was determined to be the administrator of the estate. And let me step back. So the difference between an administrator and an executor is simply if there was a will or if there were no will. So if there's no will, that person's called the administrator. If there is a will, that person's called the executor, but they still have the same responsibilities. And I mentioned it earlier, and I'll get to your question. So there are 3 main responsibilities of either the administrator or the executor. The first responsibility is to gather assets. Second responsibility is to pay off creditors. And the third responsibility is to distribute assets. So in your case, Lisa, whoever was determined to be the administrator, part of their role and responsibility in gathering the asset, because gathering also means making sure that it's there and bringing it into the state to be able to pay off any creditors. So if there's a mortgage or their credit card bills or anything, you have to use assets to be able to pay off and then distribute. So in this case, the administrator would have to petition the court to get the authority to evict the client or do something of that nature to get the property in the estate and be able to follow the guidelines that have been given to that administrator.
And more than likely, wouldn't she want, so if the four siblings want the home sold, right? They're like, we want to sell the house. So you're saying they could evict the sibling that's still in the house. They could, right? And then they could sell the house and then they
They
could divide
could.
the
So
assets.
again,
They
this
could.
all involves the judge, and at the end of the day, the judge. So they would have to petition the court, and the judge would end up making the ruling. So again, I've never been a judge. Don't pretend to be one, but he or she would have to look at all the factors in place and dictate, okay, does this house need to be sold? But again, I think even before the siblings get to the point of the money's coming to us, remember what part two is. Part two is paying off creditors, because that's important. Before you can distribute or get anything, you have to pay off creditors. So if the mortgage on the property is 90,000 and it only is worth a 100,000, you're only splitting 10,000, not 100,000. So that's important to at least know.
But I feel like this is a very good question. But I feel like when I'm talking about keeping wealth, what happens is sometimes, not in Lovely Lisa's situation, but sometimes the sibling that's living in the house is not paying anything.
Correct.
And they're not paying the taxes, they're not paying
Correct.
the mortgage. Then you
Correct.
have a foreclosure situation. You waited years and years, and then nobody gets anything. I'd rather
Correct.
get some of that $10,000 than zero, right?
I
So I feel
completely
like you have to move quickly if y'all want to try to preserve some of that wealth.
Oh,
That would be my
absolutely.
advice.
And the fact that it's been 14 years, to be honest, Lisa, again, I would say make sure you seek attorney's counsel, because there are factors as well. Because 14 years causes there to be a trail. So whether you agree to it or the siblings agree to it or not, if she's lived in there for 14 years, and I'm not sure if that's the case, she could have moved in last year. You now have in her defense, you now have a track work where she's saying that you guys agreed to this understanding, and it's been this amount of years. But I would say again, seek attorney counsel, whoever the administrator is. Hopefully the person living in the house isn't the administrator, but whoever the administrator is, make sure that they petition the court to get this matter resolved.
All right, this is all great information. Please take a minute and like and subscribe to this kind of content. We really appreciate it. We have 173 people on the chat.
Oh, wow.
Please, number one, tell your friends to watch. Either watch now or watch the replay. But good information. Take a second and hit the like button for me, please. All right, let's get back to a question. I saw one about a ladybird deed, which I don't know what that is, but it says, do ladybird deeds prevent probate court?
So I'll say in Georgia, and I had this question earlier about a POD, a payable on death deed, or some form of deed. Georgia is very straightforward where we are. We only have a certain type of deed: general warranty deeds, limited warranty deeds, quick claim deeds for the most part, and those are all. There are certain states that have things like a ladybird deed. So I'm not too familiar with it, so I won't speak to it. I will just say that Georgia itself does not have that type of deed. But again, it goes back to the idea of within a conveyance or document setting up beneficiaries, so that if somebody passes, that the beneficiaries listed under the deed would inherit the property. Georgia, unfortunately, is not as complicated as other states, and so we don't have those variations.
Okay, very good. All right, this had a question. Are there ongoing fees associated with trust and probate court? You know how people say we're losing a lot of money going through probate. How are they losing money?
All right.
How
So
is the money usually lost?
okay. So it depends on the trust. So when I talk to clients and we create an estate plan, especially if it's a trust-based plan, we talk about, upon your death, what do you want to have happen? In most cases, the client wants the estate to be distributed to the beneficiary, or distributed over a period of years. So the costs associated really is with the maintenance and the managing of the trust after the person has died. Because for the most part, when you are living and you are the trustee, you're not going to charge your trust anything to be able to maintain or manage it. But once you die and your trustee again needs to continue to maintain it, there may be some compensation to the trustee. There may be compensation to other people that the trustee has to hire, professionals that the trustee has to hire to continue to maintain it. Also, if you die and the trust has income producing assets. So let's say it's maintained over years and there's real property or there's investment properties within the trust, it gets taxed at the trust rate. So, and that rate, unfortunately, is a little higher than your individual rate. So really, as I tell clients, you're doing a cost benefit analysis on any sort of estate plan that says keep things on indefinitely or for a period of years afterwards. You're saying, yes, I want to maintain, control, distribute, and gather and maintain the wealth. But you're also saying, hey, there's going to be some costs, accounting, taxes, all those costs that are typically there with any sort of income producing asset. Probate, yes, the same thing with probate. There's fees to petition. There are fees potentially on the probate, the attorney assisting you. And what people sometimes don't understand, there's also a fee when you close, because one of the things you want to do as executor, open the estate, do the things that we talked about to resolve the estate, and make sure you close out the estate so that you're not in the future held to any liability as the executor or the administrator for anybody that comes up afterwards claiming against the estate.
Okay, good answer. Good question. All right. So if you are living in a primary house, like the house you live in, does it make sense to put it in a trust if you may one day sell it?
And my answer is absolutely yes.
Okay.
Again, just because it's in a trust doesn't mean that you don't have the ability to do anything. As I like to tell my clients, a trust is simply what I call your alter ego. So you can do exactly the same amount of things that you can with an asset in the trust as with an asset outside of it. So in the case of your primary residence, when you transfer it to the trust, you are now technically the trustee of your trust. And that's who owns the property. So if you want to sell the property in the future, all you would have to do is show proof that you are the trustee of your trust. One of the most important documents that I tell my client, because a trust is a private document, you don't necessarily have to share any of the terms of your trust with anybody. And one of the ways that you don't have to do that, what I tell my clients, is an important document called a certificate of trust or certification of trust or privacy affidavit. It's a document that's presented that tells the person who's receiving this document that, hey, the trust exists. I'm the trustee. I have authority to act on behalf of the trust. And Georgia law requires that you accept this as proof that the trust exists. And
Okay.
so if you were selling your property and I was the closing attorney, hopefully I am the closing attorney.
Yeah, put them on your clothes if you're in Georgia. Yeah.
Absolutely. Then you would just present me with a certification of trust showing proof that you're the trustee, and then you'd be able to manage and handle the closing of that property.
And they actually change your deed. So when I did my trust, now when you look up my deed, it still says our names, but it says trustees for the property.
Correct.
Yeah. So
And
they
so
will.
when you sell it, you're just selling it as trustee of the Shahida Hill Trust or the Hill Family Trust.
All right, here's a question, Sheed. We are here. How do you find a trust if there are lost through family passing and have no knowledge? So, how do you know if your family has a trust, if there are these private documents or has a will? How do you find out?
It's a great question. Yeah, you would have to have, so unlike a will where, first of all, unlike a will where you need to have the original, because for the most part, you need the original to petition the court. There are variations. If you can't find the original, you can do certain things to go around. It just makes it a little harder. So, but a trust, you can have a copy of the trust and still be able to act as trustee. Now, how do you find it? That, again, the only way that I would be able to tell you that you can find it is by looking to see how assets are titled. So, for instance, primary residence, public deeds are public records. So there's a way to look, the tax bill. The tax bill will typically come in the name of the trust, and so that tells you that the trust exists. Now we tell clients all the time, because we give clients, and I wish I had my binder here to show you, but we give clients this nice red binder that has estate planning on the estate planning portfolio on the front, and we tell them, hey, there's no need to hide this, because if a thief or a burglar breaks into your house and they steal this, they're not really stealing anything. So put it in a place and make sure that especially the people that you have is what I call successor trustees, the people that will replace you. Make sure you tell them where those documents are, and even share with them copies, because what we try to do in my practice is we do two things. We give you the physical copies. So the physical copies, but we also email you digital copies, PDFs, and then we have a secure portal that you have access to, and we store it in that secure portal. So I always tell people, make sure that your trustees, especially the trustees, have access to those documents, or that you give them those documents, to avoid this situation where we're trying to find where the document is.
Okay, good question. Just to set the stage, those of you that are just joining us, we're about 30 minutes in or so. So this is general information. However, Attorney Barlay is licensed, not licensed. What are you, barred?
Oh, license, absolutely. Barred,
Licensed and barred in Georgia.
Correct.
So that's why he's speaking to Georgia. But a lot of this stuff is applicable in your state. There might be a bit of a different rule around it, but a trust and a will can be purchased by an attorney in any state, right?
Yeah, so about 80 to 90% of what I'm talking about is general. It'll apply everywhere. There are the 15 to 20 to 15% or 10% is Georgia specific. And whenever I mention something that's Georgia specific, I will say here in Georgia. But for the most part, most of my explanation applies to all 50 states.
All right, thank you so much. And I will have all of his information in the description of this video. And if they're in another state, can you do a referral to someplace else, to another attorney?
So absolutely, I can. Okay. And in fact, what I would counsel anybody on here, if you want to seek out an attorney, I'm part of a national network of estate planning attorneys, and it's very simple. If you go to estateplanning.com, you can put in your zip code or your city address, and you will find a list of attorneys similarly licensed or barred as I am to be able to assist you. So estateplanning.com will definitely help you.
All right. But if you're in Georgia, you're going into Attorney Barlay.
Yes.
Okay. All right. Tony
Absolutely.
G has a question. My dad owns a few acres of land. He wants to give me an acre of it. What does he need to do to have it registered under my name?
All right. So great question, Tony. And I'm going to segue off before I answer your question. So I believe in generational wealth. And so it's very hard for me to hear the taking off of property an acre at a time. The property holds value when it's kept together. But again, and so I always try and counsel, keep the property together to be able to pass that on to generations, whether it's using the property to do X, Y, and Z. But that's just my soapbox. But your question, Tony, so how would that happen? So he would have to first get something done like a survey. So he'd have to survey the entire property and survey out that portion that he wants to give to you. Because then that survey is going to give the boundaries of the portion. It's more importantly also going to give the legal description of that portion. And so with the legal description established, your father can now do a deed, ideally a limited or general warranty deed, transferring that portion of the property from him to you.
Okay, so very good.
That's how you would get it into your name.
All right, so handle that business. But I think what he's saying is I had this similar situation. I went to go visit my aunt who's 95, in good health, everything. She's widowed, but they live on like family land. Yeah. And so they separated all of it out. And when people needed money, they sold it to people outside of the family. So it's like family, some random person, family.
Exactly. That's the problem. Now you diluted the family wealth. What I would say is create a family LLC. Again,
let's talk about it. Say it right now.
Every situation is different, but create a family LLC whose sole responsibility is to keep the wealth within the family. And the percentage of this family LLC that you own is based off your percentage to the original owner. So if you're a child, and let's say 5 children, then you each get sort of 20%. If you are the next in line, then you get a smaller percentage. But you keep it in the family because it creates wealth. You can, at the minimum, pay for things like taxes, either by selling timber if there's timber on the property, or by allowing people to hunt if there's there. But it gives you the opportunity to build generational wealth by coming up with ideas of how to keep that property and generate at least the minimum to pay the taxes. Because when we start trying to get money, that's when we start diluting that wealth.
And let me say this: do you help people do that, like build the LLC and then put the land in the LLC?
Yes, ma'am. Yes, ma'am. So I do, as an estate planning attorney, I do create companies for my clients to be able to do just that.
Okay. Yeah, we definitely do that because I know a lot, we talk about Black history. A lot of us have land in the South, but we went to up north for jobs. And then as people retired, they came back down South. But now the land, a lot of people have passed away. So it's not like 4 people own it. Now 20 people own it. Now the grandchildren own it. So you need to make sure and set up things like this in your families instead of, oh, you get an acre, you get an acre, you get an acre. And then when somebody's broke, they're going to sell that acre. And you're going to be living by people that have no interest in you or your family or what they're doing on that property.
And I'm gonna maybe I'll say this maybe as a record. So my idea of my retirement when I retire is to create sort of a nonprofit that will consult with families that own large acres of property and try to figure out ways to maintain it and keep it, because that's really where at the end of the day we are losing our wealth. We're losing that because we don't know any better, and because it's more of a I want money now as opposed to I can't see into the future to be able to see how things would be in general. So it's just counseling families to how to keep that, because there are going to be opportunities with things in the larger mass than when you break them off. You never know. There could be a highway plan for that particular area. There could be some development plan for that particular area. But the best thing is to hold it, at least at the minimum, pay the cost for maintaining it, and then start to think of creative ideas on how to build wealth from that property. They're not making any more. So property is if you look at any rich or wealthy person of any means, one of the core parts of their portfolio is real property.
Okay, very good and very excellent information. Excellent. Y'all should like just on that. Everybody like. All right. So somebody's saying, BM, can hospice take the house even if there's a will or trust? I heard that. Can hospice take your house? Or can the bills that hospice creates take your house?
Great question. So so I will tell you this. I'm a generalist when it comes to estate planning. And so I deal primarily in the wills and trusts. There are different types of areas of estate planning. There are special needs where they're either children or family members that are incapacitated, and you have to create things for them. There's elder law that deals with that. This question sort of deals with elder law in this sense. So if the answer to your question is yes, there's a possibility of them being able to do that, in the sense that if you cannot afford to pay for hospice or any sort of care, you typically will depend on the government to be able to pay that care. And what the government it does, and it's typically Medicaid. So when Medicaid does an analysis, Medicaid has a low threshold. Basically, they say in order for us to pay for your care, there has to be a need. So the last time I checked, again, because I don't practice in this area, don't hold me exactly to these numbers, but Medicaid's level is so low, they say $2,000, meaning if your estate is over $2,000, then we believe you can pay you can pay for hospice care. And we know 2,000 is too low. So what people tend to do, they have the home and they still qualify. And guess what happens? If they don't pay the hospice or the senior living or anything, then Medicaid can try to recapture whatever they've paid on their behalf, which in most cases, the only value that somebody has in their estate is the house. And so, yes, they can make a claim against the house for whatever they pay for you.
So you really need some senior planning in place. So, because your parents are going to get old. Everybody's going to get old, grandparents, parents. So you have to plan for that care if that asset, the only asset they have is their property.
You need to make sure that you have that taken care of. At the minimum, insurance, what's called long-term care insurance. So long-term care insurance will pay for things like hospice care when you're not able to do that. And again, it's important you try to get that type of insurance early on when you're young enough, because then it'll be cheaper than when you're 60, 70, 80 trying to get long-term care insurance, or if you have a pre-existing condition, that makes it even harder. So part of this, again, education piece is just making sure you go in and start reviewing and thinking about these things ahead of time.
Good information. I'm going to go a little bit faster, Attorney Barlay, just because we have a lot of questions. So Lovely Lisa is back. She made a correction. She said it did not go into probate. Remember that this was the one where 14 years ago her mom passed away. 4 siblings, 5 siblings. One is living in the house. So does she have to now go to probate?
Yes, there's
Immediately.
no doubt. You have
Today.
to be in order for whomever to act on behalf of the estate, you have to administer the property. So somebody has to go to the probate court, file the necessary petition,
Let me say
and
this,
be
in that
granted
area. They can't go to their probate court in their state.
It
Say they
has to
live
be.
other places.
It's the probate court in the county where the person passed away. So that may not necessarily be in the same place as the house, but that typically is, especially if it's primary residence, it's the county where the person passed away as a resident of that county.
Okay. And don't wait. Get on that now. Because you already waited 14 years.
No, it's
All right.
Absolutely.
Can we modify, add, or subtract assets in a trust at any time? Will we have to pay a trust startup fee to the lawyer each time we make a modification? So basically, we have to pay to take things in and out.
Great question, BB. Yes, we take a picture in time. So upon creation, we take a picture, and that's how things done. Depending on the attorney, if there are modifications and amendments done throughout the trust, there are fees there, but they're typically smaller. So in my case, and I can't speak for every attorney, if it's $4,500, then maybe it's $295 or $395 when we make those changes. But that's why I go back to the rule of 3. What we're trying to avoid is changes because of trustee or your power of attorney or somebody, because you have backup in place. If the first person not available, you don't have to come back and make an amendment or a change to your document. You have 2 or 3 acting there. But I always tell people, review for life changes, birth, death, divorce, marriage. Yes, then you have to reconsider what's in your estate plan.
Yeah, there's a lot of ex-spouses getting inheritance because y'all didn't change your life insurance.
Absolutely.
For sure.
Absolutely.
All right, BB. All right, ask that question. Sorry. Angela, when do our bills die when we do, or do family members inherit them? I know student loans die when you die, for sure. Like government student loans, they die when you die.
But remember, for the most part, they do not die. Meaning, remember what I said in terms of responsibility. Gather assets, pay off creditors, and distribute the assets. So your bills, your family members don't necessarily inherit them in terms of them paying it directly, but your estate has to pay those off before they pay it. So if there's money in the estate to pay those bills, they have to before family members get anything.
Right. You even have to pay their taxes. So if they die, the tax year that they died in, you have to file their taxes if you're the administrator or the executor of their estate. All right. Good question. Correct. Anna Davis, no kids, no spouse. She has a dog, though. She's going to leave everything to her dog.
I know, cute dog.
Do I need a trust or a will?
I wish I could answer that. So the way I answer those questions, Anna, is I need more information. And typically I get calls from people, and I always say, or like in this case, tell me what color my pants are. You would think, hey, I know enough information. I have a blue coat, so my pants must be blue. But no, unless you know me better, you won't know the circumstances to dictate. So I can't tell you without knowing more whether you need a trust or a will. Are you a business owner? In that case, I say I lean more towards a trust and a will. Do you have properties in different states? Yep, you're definitely the candidate for a trust over a will. So more information is needed to be able to determine that. In general,
because what happens? So if she died without either one, right? Where will her things go? It doesn't go to her spouse, doesn't go to her kids. Who does it go to? Cousins, whatever.
It'll go to parents, then siblings, then aunts, uncles, nieces, nephews. So it'll keep going down until they find somebody.
Okay. Correct. Good question. All right, let me try to go a little bit faster. I just had one thing. Sorry. What about disabled children? I'm not sure about this. What about disabled children?
Yeah, so that's where special needs come into play, because most of the time there are governmental benefits that the children are taking advantage of. And so you don't want to have trust or wills or anything created that go directly to those individuals. You want to create supplemental needs trust that will only act in supplement or in case the governmental needs are either extinguished or don't cover entirely the care. So again, it's a niche area of estate planning called special needs planning, and you need to make sure you advise or with a lawyer that handles those particular areas.
Okay, BM, my grandmother left her house to her grandkids, but my aunt was trying to sell it. I never signed anything or gave permission. She's not answering phone calls. Could she have sold it?
So the short, it depends. But if the aunt is the executor and or administrator of the estate, then yes, maybe. So it depends. Again, gather assets, distribute, pay off creditors, and distribute assets. So if the estate is not solvent, or where the house is the only thing that can pay off creditors, then for the most part, the administrator does, or executor does, have the ability to sell property, even if the property is supposed to be given to the grandkids. So again, more information is necessary, but it just depends on her authority.
So the aunt can sell it, but she still has to take the money and give it to the grandkids.
Correct. She can't sell it and keep the money for herself, unless
Right.
she's one of the beneficiaries. But in this case, it says grandkids. No, sell it, pay off creditors, and then distribute the rest to the grandkids.
Okay, good.
And that's why I tell clients, again, if your intent is for the grandkids to have the property, make sure you have a plan in place on how that is to occur. Either pay off your creditors with some insurance, or have insurance to keep the property, or some need to be able to maintain the property for the grandkids to have.
All right. New marketing agency says, thank you for this wisdom and knowledge presentation and answering questions. You are so welcome.
Thank you.
DJ says, just got my trust done last month, just getting it funded, but I feel so much better. Yes, it's like a weight lifted off of you once you finally just get it done.
Absolutely. And DJ, so again, don't miss out on funding. Funding is very important. And I know it's difficult, but make sure you go through a checklist of everything you have and make sure everything is directed to the trust.
And funding is basically taking your accounts, every account that you own, and making sure the trust is part of it.
Yeah, either the trust is listed as the beneficiary, or the trust owns that account. That's the way you get the assets into the trust.
All right. All right. Can you register your trust and will with the courts once they're drawn up? I think this is in response to the guy saying, I can't find, if it's if there's a will or a trust.
You technically, no, you cannot. However, certain states, like in Georgia, for a minimal fee, about $5-10 or so, you can store your not really the trust, but you can store the will with the court. It can be a good thing if you know for sure that you're going to stay in that county and that place indefinitely for your entire life. But the minute you move, you have to also remember, wait, I stored it with the records with the court, so I have to get it and transfer it somewhere. But in short, you can get it stored, but that doesn't really mean anything. You still have to let your executor know where it's located so that they can go ahead and get it and petition the court.
All right, here's a good question. Lady B, what occurs in court if the siblings are not in agreement to appoint one person as the administrator?
Correct. Then it's up to the judge. So the judge makes the final determination as who is the administrator. So if two people or multiple people step forward, say, I want to be the administrator, the judge at the end of the day is going to look at various factors and determine who is the best in this best position to serve as the administrator.
Okay, good. Jay says, thank you so much for speaking on ways to keep familial land together so that it remains for future generations.
Absolutely. And I'm telling you, that's where we, and I'll speak freely, that's where we as Black folks, and again, I know that there's a gambit in terms of, I'm originally from West Africa, but it's where we sort of lag behind our other cultures, is that we tend to not keep things, especially real property, together in a sense. And so it's important for us to be able to have those conversations about trusts and things of that nature. We have to have assets to be able to do that.
Okay, this might be a little bit too complicated, but maybe just for me, not for you. It says, Ben says, somebody urged me to open an IUL account, which is a type of life insurance with living benefits. He claimed the life insurance account cannot be held by probate court should I pass. Is that true?
It is true in general. So there are probate court only can handle what's called probatable assets, which are assets that do not by law or by contract go to somebody. So an insurance policy that determines who that has a beneficiary listed there by contract will go to that beneficiary and not go through probate court. So again, it does work. What I always tell clients, you got to look at the big picture and do a wholesome sort of approach to estate planning. Make sure that you have things directed. So if you have the life insurance, make sure it's directed to the trust and make the divisions there. If you have a will, make sure it's addressing at least the life insurance in the sense that you know where that's going to go.
All right, Jay, again, for an older parent, 70 years or older, is it best to put a paid off home in the trust to avoid the 5-year look back period for Medicare? Or is there another option to consider? He don't want to lose his bar card.
Yeah.
By telling y'all to do this. She
So,
doesn't have long-term care insurance.
yeah, so that's a great question. Unfortunately, it's a question that starts delving into an elder law, and I sort of I sort of talked about it a little bit earlier. So the answer is going to be it depends. For the most part, I would say so. The type of trust, first of all, that you're talking about is a Medicaid trust. It's an irrevocable trust, and there are some benefits to doing that. There are some disadvantages to that. What I would say is seek the advice of an elder law attorney, and that attorney will walk you through the process of if necessary, of transferring that property to a Medicaid trust. Again, long-term care insurance is at the LTC. That's the number one priority, but I understand she's 70 now. It's hard to get long-term care insurance. So seek out the advice of an attorney to determine or give you the whether that's beneficial at this point, because there's a lot of numbers and factors.
The attorney cost, even if it's a few $1,000s, is probably gonna be more than the cost is gonna take you for hospice care and all those care. So make that investment
and a paid off home. I mean, so that may be a benefit in and of itself. So absolutely.
All right, good. I'm gonna go, Jay. We answered this question about putting your primary house in a trust. The answer was yes. But some of you that are coming in now, we're at about 228. Thank you for joining us. Please like this live stream. Please like it. But watch the replay because he answered a lot of these questions. I saw a good question. You keep up with Wendy Williams, Dr. Attorney Barlay?
Unfortunately not. I don't keep up with her that much. I hear about her from the
right. Well, she has dementia. So let's just say for anybody. It says, in the case of Wendy Williams, the state has taken over her estate. Is this because she did not have a trust in place prior to her dementia? So she's a celebrity. She has a lot of assets. She has dementia now, so she can't make decisions. So now it's like an administrator has it. What do you think about that?
So again, what I always tell people is while you are alive and competent, make the plans. Because if you don't make it while you're alive and well, somebody, and in this case, the state or the probate court in specific would make the determination for you. So either a trust where and that going back to one of the differences between the will and a trust is that a trust becomes effective upon signing, whereas a will doesn't become effective until you die. And so while you're alive and incapacitated within a trust, you can create or have what's called a disability trustee, somebody to handle your affairs if you should become disabled. Now, because a will doesn't become effective until you die, you have to create a whole separate document in addition to the will. And we can get into more detail, but that's why I always tell people it's a trust-based plan and a will-based plan, because the trust and will are the central documents. There are several other documents in addition to the trust and will to address needs. So in the case of this, she would need to have a power of attorney, which is a document that appoints an agent or a power of attorney, some people want to call it, to be able to handle your affairs if you were to become disabled. So my assumption is that if the state has taken over, or in this case, the probate court has appointed a person to act on her behalf, typically that person is called the conservator or the guardian. So the conservator handles their money and the guardian handles their person. It could be the same person. It could be two different people. But in this case, they are set in place to take care of her and her benefit. Again, not necessarily a bad thing, but would Wendy have wanted this particular individual to handle her affairs? Probably not. And so it's always important to go back and make those determinations while you still can.
All right. MI says, I love the topic, really needed. Thank you for joining us. T. Carmel says, can I add my son to the deed to avoid probate court?
Yes, you can. Yes, you can. Again, I always say, do not let that be a substitute for doing true estate planning, either a will or a trust-based plan. Because what you do, understand this, it's an irrevocable transfer, meaning if you add your son to the deed to title, you can't take your son off because now your son is an owner. So if you have a falling out with your son, you'd have to now go to court and figure out another fancy way to get the property back, because it's almost like a whole other process to be able to do that. So beware. Again, I'm not saying it's a bad option. I would say if you're trying to replace estate planning, do proper estate planning and make sure. Now, if it's your only son, you live with the son, he takes care of all those things. Yeah, I would lean towards, okay, deed's okay. But if you have other children, no matter how much you think your son is going to take care of his siblings, when you die, the son could potentially say, it's my property. And he would be correct. And so now he could take, regardless of your familial circumstances.
Now that we hit on that, let's talk about really quickly, just for me. And we'll take like 1 or 2 questions and we'll be done for the night. Let's talk about adding your boyfriend or girlfriend to your deed. Because we have problems with children as well, but there are a lot of people that will add, they're not on the mortgage, but they'll add a spouse. Not a spouse. And I say not a spouse because the divorce court handles those types of things.
Correct.
But a lot of times they'll add their girlfriend, their boyfriend to their deed, and they're not on the mortgage, giving them control. Can you just talk about what problems can occur?
Well, that's opening up a whole can of worms here. So again, my advice is never add a non-spouse, I don't care who they are, to the title of the property, because there are, again, as I talked about, to take them off, they have to sign to come off. Fortunately, I've been doing real estate for 20 years, and I've only had maybe 2 or 3 calls for a boyfriend or girlfriend that has left no longer on terms, and I need to either refinance or sell the property. And my response is, I'm sorry, you're going to have to find them because they're going to have to transfer the property back to you. In fact, it's become such an issue, and we always sort of deflect or ask our title insurance underwriter for questions, because we really are representing them. We're issuing policies based on their. So it's come to a point where our title insurance companies are now saying that at a closing, you cannot add anybody other than a spouse. And so that is a dictate that we as closing attorneys now have to tell our clients, I'm sorry, we have to ask you, is it a spouse? Oh, if it's a spouse, perfect. Just pay an additional deed fee and we'll add them. Non-spouse, sorry, we can't do that.
Okay. Very, very good. He said never, you guys. Never. And I concur. Never.
We lawyers like to say depends, and we like to work on spectrums, but I would say that's close to 100% that I would say do not add a girlfriend or boyfriend, especially a non-spouse, to title.
All right. There'll be our last 2 questions. Attorney, tell them how they can be in touch with you. And again, everything will be in the description of this video as well.
Perfect. Well, so my office, my main number is 770-602-9924. Again, that's 770-602-9924. You can also email. My general estate planning email is estate plan, so ESTATEPLAN at Lueder Law, so LUEDERLAW.com. So estate plan at luederlaw.com, best way to reach me, and we'll be able to assist you.
Right. And if you're not writing that down, I'll have it in the description of this video as soon as the live ends. Okay. Last few questions. Do you have to pay a monthly or quarterly fee to a trustee? Do you have to pay them?
Not necessarily, no. I mean, no, I wouldn't say though. Again, you are the trustee upon your death. So unless you're not able to serve as a trustee, typically 99.99% of the trusts we create, the person that what I call the settlor or the grantor or the trustor, whoever creates the trust is the initial trustee. And so there's no fee. Now, when you pass away or become disabled, most trusts will say reasonable compensation. But that's why I say select family and friends first before you try to select a professional trustee, because most of the time family friends won't charge the trust to serve as trustee.
All right. Last question. If a person doesn't have a lot of money, land, etc., wouldn't a will be better? I guess because it's less expensive.
Yeah. If cost is an issue, then a will is better. But again, I would say trusts are typically better than will. But again, if all of those circumstances are the case, then yes, I would say have a will. A will is better than not having one at all. So just make sure it encompasses everything that you want. But wills are fine. And in fact, this is why I'll go back to Georgia. Georgia is better than a lot of states when it comes to the probate process. And so that's why some of my clients, I will recommend a will over a trust, simply because of the factors like some of these that are mentioned here.
All right. Well, thank you so much for joining me. Please like and subscribe to my channel if you haven't already. Any closing thoughts on this Black History Month? What would you hope that, I know you said for the generational wealth, is there anything else you would hope like Black people did more
Yeah,
to
just
protect their
plan.
wealth legally?
And it's planning. It's planning, and it's having conversations with people that can happen. We use these analogies about being in a room. If you're the smartest person in the room, then you're in the wrong room. That's how you think about with almost any sort of knowledge and education, especially now with the advent of social media and the internet. You can gain and garner more knowledge. So always seek out people who may be able to provide you with advice and learn, and most importantly, plan. Because again, if you don't have a plan in place, the state will have a plan for you. And so you want to try to avoid that. But it helps, because the more you plan, the more you can have those conversations with your children, and they can have it with their children. As I tell folks all the time, it's easier. I have conversations with my clients. I have white clients, Black clients. For some reason, my white clients know more about trust than my Black clients do. I'm doing more education with my Black clients. Why? Because my white clients, oh, my grandfather had one, or my parents had one, and it's an easier sort of opportunity. So have conversations with your children, even if you don't end up creating a trust. Have a conversation with your children based on what we've talked about here, based on your individual research about the importance of doing planning. And again, if you can't do it, or you're not able to, your children will pick up on that and have that ability to be able to do that in the future. So we're really just building that knowledge base, to make sure that we're at the level where we can make those decisions.
All right. Thank you so much, Attorney Barlay. I really appreciate you every year coming on with me and sharing your knowledge. Thank you so much. Say thank you in the comments. Everybody have a great night. Bye-bye.